It wasn't just Jay-Z going on the offensive against the lawyer who helped file a sexual assault lawsuit against him, but now it is Sean Combs, the embattled rapper and producer who's currently sitting in federal lockup as he awaits criminal trial, has now actively sought to oppose attorney Tony Buzbee's efforts to be admitted in New York as part of a separate lawsuit. New arguments and allegations are being leveled against Mr. Buzbee, and we are going to break it all down for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. And by the way, I know that we have a lot of sponsors on this show, and look, we appreciate you supporting them, supporting us, but I'll tell you what, we'd actually really like to know from all of you, our loyal Sidebar audience, the Sibinians, if you will. It's a terrible name, I gotta workshop that. Anyway, we wanna know, what do you all like? So we created a 5-question survey. You can tell us what kind of brands and products you use, which would just be super helpful to us to make sure we put the right companies in front of you guys. Also, if you fill out the survey as a thank you, we're gonna randomly select 5 of you and send you free Law&Crime t-shirts. So please fill out the survey at lawandcrime.com/survey. It'll take less than 30 seconds and you could win free Law&Crime merch. Okay, interesting legal issue brewing in one of Sean Combs' lawsuits, and it kind of intersects with Jay-Z. I'm going to explain why. So, as Sean Combs awaits trial on federal sex crimes charges with a trial scheduled in May, as you know, no secret, he has been hit with a multitude of lawsuits. And one of those lawsuits is from a woman named Candace McCrary. Now, Candace McCrary is actually somebody who initially filed a lawsuit against Sean Combs as an anonymous Jane Doe, but she was ordered by the court that she would have to refile her lawsuit with her real name if she wanted this to continue. She couldn't continue the case using a pseudonym because the judge held that it wasn't fair to Sean Combs, that he had a right to know who the person filing a lawsuit and accusing him was. And that was for purposes of investigation, for purposes of challenging her credibility. But also, she highlighted, the judge, that the public has a right to openness in judicial proceedings. And that is what Candace McCrary did. She refiled this lawsuit under her own name. And by the way, that's significant because you might have an accuser say, if I have to be publicly identified with that pressure, with that spotlight, I'm just going to abandon the case. So for this Jane Doe to go forward and now identify herself and say, I'm Candace McCrary, let me tell you what happened to me, that's significant. Now, what did she allege? Well, she alleged that in 2004, she was at a party when all of a sudden she was escorted away to a separate room by a security guard who simply allegedly said to her, you know what you're here for. He allegedly locked the door and left her and her friend inside with Sean Combs. And according to her, Sean Combs allegedly forced McCrary's friend to perform oral sex on him, or else he would have them both killed. That's a threat that he allegedly made. And when it came to McCrary, here is what the complaint reads, quote, Combs soon turned his sights to Miss McCrary and forced her to take her clothes off, again under the threat of violence. Once she was undressed, Combs forced himself on her and began to sexually assault her. Combs fondled, molested, and ultimately raped Miss McCrary, all while she was begging him to stop. Soon, and likely due to Miss McCrary's cries, the door opened and the security guard from earlier came in to ask if everything was all right. Miss McCrary's friend took the opportunity to rush out of the recently locked door. Miss McCrary, however, could not move as Mr. Combs was still on top of her. Combs got off Miss McCrary to talk to the security guard. He left the room but told Miss McCrary to stay, otherwise she would be killed. After about half an hour of sitting in the dark room by herself, another security guard came and told her that she could leave. Miss McCrary gathered her things and left immediately and called a taxi back to her dormitory in downtown Brooklyn. Just a harrowing account. Allegations, this is all that it is right now. Allegations, still has to be proved, but nonetheless, harrowing allegations. Got to say something. So as this story and most of the stories that we cover on Sidebar show, the world can be something, to say the least, right? And it's scary thinking about how to protect yourself. And we always try to partner with companies that can maybe help you out in providing some security. Well, I'll tell you what, we have one for you right now, our sponsor, Delete Me. Because did you know that your personal data is being harvested and sold online by data brokers? Yeah, anybody can buy your personal details. And when that happens, you are at risk for a whole host of things. Identity theft, phishing scams, potential stalking. But Delete Me helps keep your personal information private. I mean, they found dozens of data brokers that had my information. They had to remove it from multiple listings. And by the way, Delete Me will keep monitoring those sites for you so your information doesn't find its way back on there after the first removal. And using Delete Me has given me some peace of mind too about my family, because if someone buys your data via data broker, they can see information about your relatives too. So right now you can get 20% off Delete Me and protect your personal data when you go to joindeleteme.com/sidebar and use promo code sidebar at checkout. Now let me tell you what is going on right now, what we want to talk about. So, Texas attorney Tony Buzbee, somebody we have mentioned a lot here on Sidebar, the man who famously held a press conference months ago indicating that he was representing dozens of Sean Combs accusers, who, by the way, he has already filed a number of lawsuits on their behalves. The man who filed a lawsuit against Sean Combs and Jay-Z on behalf of a woman who claims the rappers raped her when she was 13 years old, only for that lawsuit to be voluntarily withdrawn by Tony Buzbee himself. Not entirely clear why it was withdrawn, but remember, there was a lot of apparent holes in Jane Doe's account. This was based on an investigation conducted not only by Jay-Z's lawyers, but also NBC News. But now, Tony Buzbee wants to get involved in this Candace McCrary lawsuit. And more specifically, he is moved to be admitted to be the attorney for McCrary in New York on a pro hoc vice basis. Now, in other words, that is when you ask the court for permission to temporarily represent a client in a jurisdiction in which you're not licensed to practice. Now, in his motion to be admitted, he writes, "I'm in good standing of the bars of the state of Texas and New York, as well as the Eastern District of New York." So even though this particular lawsuit was filed in the Southern District of New York, he explains he's in good standing in a neighboring federal court. And in fact, in the filings, there is what appears to be an official certificate of good standing of Tony Buzbee from the Eastern District. There is also apparently a statement of his good standing and license to practice law in Texas. However, as explained in Tony Buzbee's affidavit in support of his motion to appear pro hoc vice and his actual motion, he does acknowledge that a grievance or a complaint of misconduct was filed against him in the Southern District of New York, that he didn't realize that he had this grievance filed against him until he tried to apply for admission. And he also says that the Committee on Grievances in the Southern District had previously denied his petition for pro hoc vice on February 13th. But Tony Buzbee explains, despite this, he says he's never been censured, he's never been suspended, he's never been disbarred, he's never been denied admission to court, and he intends to fight this grievance. However, he explains in his affidavit, quote, "The primary factor underlying both the grievance and the Southern District admissions decision is that I electronically signed numerous pleadings alongside my firm's local counsel, who is admitted to the Southern District of New York, who actually filed all pleadings and other papers. To the extent I violated the Southern District's rules in so doing, those violations were inadvertent, and I sincerely apologize. I intend to explain as much to the Southern District's Admissions Committee and will make certain such never occurs again. As an aside, included in the grievance, although I'm unclear whether it is a basis for such, was information regarding the filing of a lawsuit against me by a former client. That case, once it achieved a headline, was immediately dismissed, and the basis for that filing were completely fictional, all of which will be demonstrated by evidence to be presented to the grievance and admissions committees." And let's not forget something. During Tony Buzbee's fight with Jay-Z and Jay-Z's lawyers during that litigation, with, again, the woman who claims that she was raped by Jay-Z when she was 13 years old, the rapper's lawyers raised an argument. They raised the argument that Tony Buzbee was violating ethical rules and didn't even seek to be admitted pro hoc vice on an interim basis before signing his name to pleadings. It's going to come up again in a second. So I say all of that to talk about what's happening now, because Sean Combs' counsel has made a new filing. It is in opposition to Tony Buzbee trying to get admitted pro hoc vice in the McCrary case. They have now gone on the offensive against him, and that is what we're going to get into right now. Here is the opening paragraph in this opposition paper. It reads, "In our collective decades of practice, undersigned counsel have never opposed a pro hoc vice application, and we do not do so lightly here. But Buzbee's egregious misconduct warrants denial of the privilege of appearing in this district. He has signed multiple filings across 22 cases without permission to practice in this court. He failed in each instance to disclose that he had filed without being admitted, and he violated New York's rules of professional conduct by, among other things, repeatedly insisting that Mr. Combs is guilty of the criminal charges pending against him in this district, even though Buzbee has no good faith basis to believe the government will call any of his clients as a witness in that case. For these reasons, discussed in detail below, this court should deny Buzbee's pro hoc vice application. Now, for the record, you don't usually see this a lot. Opposing counsel, they don't really object to who the other side wants to represent them. So this is a unique situation. It goes on. As plaintiff's lead counsel in this case, Buzbee has for months been signing and, upon information and belief, drafting, directing, and advising on pleadings and other filings in this action, and others, without obtaining permission to practice in the Southern District of New York and without disclosing that he lacks such permission. And then they cite a number of filings that were allegedly signed seemingly improperly by Tony Buzbee, like the complaint, like a motion for reconsideration, and so forth. And they argue that he did the same thing in 21 other cases. That over the course of 3 months, he, quote, directed the filing of and litigated cases in the Southern District without having applied for regular or pro hoc vice admission. Quote, Buzbee never indicated in a single action in this district that he was not admitted here, that he had no application pending here, and that he had not sought admission pro hoc vice. And they argue that it wasn't just he was filing these papers without the proper authorization, but they also took issues with public statements he was seemingly making at press conferences, on social media, and in interviews. And really, they claim, they argue, that he violated the rules of professional conduct by opining on Sean Combs' guilt in the criminal case. More specifically, they write, worse, he has falsely accused Mr. Combs of sexually abusing dozens of children when Mr. Combs has never been charged with such crimes. That's right, he's never been criminally charged with respect to minors, although Combs has been accused of that in numerous lawsuits. And by the way, to make this very clear, Combs denies not only that, but he denies all accusations of sexual misconduct. Women, men, children alike, has been denied all of the allegations in every lawsuit he's faced. He has denied the allegations in the criminal case, and apparently he's looking forward to his day in court. Okay, putting that to the side. From there, Sean Combs' counsel explains what happened with Jay-Z, namely that Jay-Z's counsel had filed a letter with the court in that case, the one about the Jane Doe, the 13-year-old, disclosing that Buzbee hadn't been admitted to practice in the Southern District, even though he apparently signed a number of pleadings and other filings. And they also claim that Tony Buzbee wasn't honest with the court in that case when he said that he was admitted to practice in the Eastern District and his reciprocal admission in the Southern District was forthcoming. They said he was kind of misrepresenting what was going on there. And according to Combs, Jay-Z's counsel, they made the claim that 6 days after making this alleged misrepresentation, only after the judge ordered Tony Buzbee to file proof of admission, that is when he applied the following day. Now here's the thing. They then explain how on February 13th, as I mentioned, the grievance committee in the Southern District of New York denied Tony Buzbee's admission. The filing goes on to state, quote, Buzbee was denied admission because per the committee's review of the dockets, Buzbee has appeared in cases in this court without seeking admission. The final sentence of the order denying admission states, in the event Buzbee moves for pro hoc vice or regular admission in this court in the future, he must attach a copy of this order denying admission to his motion or petition. Meaning, if he ever tries to be admitted, whoever's going to be doing that admission process, they got to know that he's had this issue in the past. It goes on to say, Buzbee took no steps to notify this court or any other court in this district where his actions were pending that he had been denied admission to practice here. Instead, in this action and others, Buzbee continued to appear on court filings without disclosing the adverse action the district's grievance committee had taken against him and without seeking admission pro hoc vice. And here is where things get even more dicey for Tony Buzbee, according to Sean Combs' counsel. The court apparently issued Buzbee a warning. Quote, the court notes that plaintiff's letter is signed by Anthony Buzbee. The court has been informed that Buzbee is not admitted to practice in the Southern District. He's not filed a motion to appear pro hoc vice in this case. As such, Buzbee is in violation of Local Civil Rule 1.3. Accordingly, it is hereby ordered that Buzbee must file a motion to appear pro hoc vice no later than February 21st, 2025. And that if he doesn't do that, he could be sanctioned. So, Sean Combs' lawyers claim that Tony Buzbee files a motion to be admitted pro hoc vice only after the court required it, and that this was the first time he ever did that since he started filing cases in October. And then they mentioned that affidavit that Tony Buzbee filed, which I mentioned before. Okay, so from there, in Sean Combs' filing, we get into the law in support of why they argue Tony Buzbee's motion to be admitted to this court in this case pro hoc vice should be denied. First up, they explain how when a lawyer is admitted and in good standing in another state or in a district court, they may be allowed to argue or try a case on a pro hoc vice basis. That's the standard. And there are certain things a lawyer has to do, including electronic filings, paying fees, things like that. But they also emphasize that based on case law, quote, a lawyer's pro hoc vice admission is a privilege, not a right, that it's up to the discretion of the court to grant it. And one of the things that courts will look to is to make sure an attorney can be relied upon to be truthful with the court. And they even cited a case where an admission was denied when an applicant didn't tell the court about an administrative suspension in another court. So you can see how they're setting the ground for Buzbee that he wasn't forthcoming, he should be denied admission. And they continue, quote, although pro hoc vice admissions are routinely granted, the court's decision to do so is not simply a pro forma exercise, and there are occasions where such applications have been denied. And they get into that argument a little bit more. Quote, Buzbee's motion for admission pro hoc vice should be denied because he has repeatedly shown that he is unwilling or unable to follow this district's local rules and because his application is deficient. For nearly 5 months, Buzbee has filed case after case in this district against defendants in the name of anonymous plaintiffs without seeking admission of any kind and without disclosing his lack of admission until raised by a court or adversary. He did not apply for admission to practice in this district until January 29, 2025, more than 6 weeks after his failure to do so was publicized in a letter filed by opposing counsel, 5 weeks after he represented to another judge in this district that he intended to apply for admission, which he only did after opposing counsel disclosed Buzbee's lack of admission, and 2 weeks after he represented to another judge in this district that his application was forthcoming. Even after Buzbee was expressly put on notice by the Committee on Grievances that making repeated submissions to courts in a district where he's not authorized to practice violates the local rules, a concept so fundamental to the practice of law that it requires no forewarning, Buzbee took no corrective action. Instead, he continued making filings in this district without noting his lack of admission until this court required him to seek pro hoc vice admission. If this court had not noticed that Buzbee was practicing without being admitted, there is every reason to believe that he would have continued to do so because that is precisely what Buzbee is doing in more than 20 other cases pending in this district. Even after declaring in a February 20th, 2025 affidavit submitted to this court that his errors were inadvertent and he will make such certain conduct never occurs again, he has failed to seek admission pro hoc vice in any of the other pending cases. But now I want to highlight something else, and this is interesting. So Sean Combs' counsel argue that either Tony Buzbee's repeated violations show he's not familiar with how to properly practice in this district, seemingly meaning he shouldn't be admitted, or they argue this shows he can't be trusted and to conduct himself following the professional and ethical rules, and again, he shouldn't be admitted. And they argue that courts have denied pro hoc vice admission even when the other side is not opposing them if a lawyer's repeated violation of the rules shows they aren't competent to practice here. And talking competence, here they argue Tony Buzbee doesn't understand the local rules and local practice. They also say he violated federal rules of civil procedure and local Southern District rules when he filed a lawsuit under a pseudonym, meaning Jane Doe, without first getting permission from the court. And they claim he did that in other cases too. They also argue that his actual application for pro hoc vice was deficient. That it was deficient because he was supposed to explain the facts and circumstances of a disciplinary proceeding, and simply stating in his affidavit that the reason he had a grievance filed against him is because he, quote, electronically signed numerous pleadings alongside my firm's local counsel, and further noting that the grievance included information regarding the filing of a lawsuit against me by a former client, they argue that's not enough. That's too bare bones a description. That is not properly describing the nature of these circumstances as is required. So they argue he doesn't know how to follow local rules, he doesn't know how to follow federal rules, and his application is deficient. But they also argue that he violated the New York rules of professional conduct. Those are our ethical rules as lawyers. But more specifically, they claim that he violated the rule that prohibits attorneys in a case from making out-of-court statements that the lawyer knows or should know will spread and have a substantial likelihood of prejudicing the case in a material and relevant way, such as about the character or credibility or even the criminal record of a defendant or a plaintiff or a witness or even the guilt or innocence of a defendant. And they argue that his press conference, the one I mentioned before, the one back on October 1st, 2024, it did just that. Because you remember, Buzbee announced that he was going to be filing lawsuits on behalf of 120 different people and that there would be a 1-800 number for people to call if they had claims against Sean Combs.
The wall of silence has now been broken, and victims are coming forward. Our team has had at this point more than 3,285 individuals contact us with people claiming to have been victimized by Sean Combs. We now represent 120 individuals who intend to bring civil claims in civil court against Sean Diddy Combs, as well as claims against many other individuals and entities that we will name as defendants as we file these individual cases.
And Sean Combs' counsel claims here in this filing that Tony Buzbee claimed that one victim was 9 years old, that he claimed to represent 25 people who were abused by Combs when they were children, that he described his client's potential testimony, including where the alleged assaults took place, the circumstances surrounding them, and that this is all inappropriate. Quote, Buzbee did not just preview his client's expected testimony in general terms, he relayed anticipated accounts of the as-of-then unfiled allegations from specific unnamed clients. In describing his client's expected narratives, he claimed that he had corroborated, vetted, and collected evidence for each of the accounts he presented, vouching for the truthfulness of his client's allegations and implicitly of Mr. Combs' guilt. After the press conference, Buzbee went on to participate in a media blitz campaign to promote his lawsuits, and in doing so, he routinely implied that Mr. Combs has a, quote, predilection for predatory sexual assaults, commenting on and denigrating his character. There can be no serious dispute that such statements had a, quote, substantial likelihood of materially prejudicing this and other adjudicative proceedings in flagrant violation of Rule 3.6. That's the rule I was talking about before. And they go on to write, indeed, even though none of Buzbee's clients is expected to testify at Mr. Combs' criminal trial, Buzbee's extrajudicial statements, out-of-court statements, are likely to prejudice Mr. Combs' criminal case as they unambiguously express opinion as to the guilt or innocence of a defendant and relate to the character, credibility, reputation of a party suspect in a criminal investigation. So in other words, they argue he violated the rules of professional conduct and the local rules. He failed to seek admission when he was supposed to. He provided a deficient application, and therefore he shouldn't be allowed to practice pro hoc vice, and the court can't be confident that it can rely on what he says or promises. And then Combs' counsel adds this. Moreover, his public statements reflect that he does not appreciate the gravity of his violations. Indeed, rather than acknowledge the limitations of his practice authority in the face of public inquiries about the denial of his admission application to the Southern District of New York or remain silent, Buzbee instead chose to make a public statement that deflected, claiming that reports of him being barred from practicing law in New York State were trash and pure bunk, and boasting, although I prefer Texas, I'm proud of the legal work we're doing in New York. So that is actually from an accompanying exhibit in an affidavit from one of Sean Combs' lawyers, and it features a screenshot of what appears to be an Instagram post by Tony Buzbee, and it reads in full, I receive many press inquiries and make no effort to respond to most. I prefer rather to make a one-time general statement and let the various entities use that statement as they see fit. Over the past week, I've gotten multiple inquiries from friends and colleagues expressing concern and asking why I've been barred from practicing law in New York State and offering their assistance. I myself have seen several press agencies, some borderline legitimate, reporting that same trash. Let me be clear. I'm licensed to practice law in New York. I'm in good standing with the state bar and have always been. Although I prefer Texas, I'm proud of the legal work we're doing in New York. Don't believe the clickbait or dramatic headlines. Most of what's reported nowadays is pure bunk by those with an agenda. So, in response to that, Combs' lawyers write, while it is apparently true that Buzbee is admitted to practice law in the state courts of New York, his public statements in response to the order denying his admission to the Southern District of New York are deliberately misleading. Against this backdrop, the court cannot credit his promise that he will never repeat his misconduct. Indeed, there are at least 19 other judges in this district to whom he has not yet disclosed the order denying admission and from whom he has not yet sought permission to appear pro hoc vice. So in conclusion, Sean Combs' lawyers write, for the foregoing reasons, defendants respectfully request that the court deny Buzbee's application to appear pro hoc vice. We will see how this shakes out. Interesting development we thought we'd bring to you, but that is all we have for you right now here on Sidebar, everybody. Thank you so much for joining us, and as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.